rise. Oyez, oyez, oyez. The United States Court of Appeals for Veterans Claims is now in session. The Honorable Margaret Bartley presiding. All who have business before this court draw near, and you shall be heard. God bless the United States and this honorable court. Please be seated.
Good morning, everyone. I'm Judge Bartley. On my right is Judge Allen, and on my left is Judge Falvey. And we're here today for the matter of Reginald L. Smith versus Wilkie, docket number 1811-89. And the issue before us, among other things, is whether the board violated fair process or due process when it reversed a prior, non-final, favorable credibility estimation without providing notice of this and an opportunity for the veteran to respond. Counsel for the parties, please state your name and your appearance for the record.
Good morning, Your Honors. John Niles and Kimberly Park, representing Mr. Smith.
Thank you.
Good morning. Joshua Walensky on behalf of the Secretary. With me at counsel's table is James Cowden.
Thank you. Each party will have 30 minutes to present their arguments. Mr. Niles, do you want to reserve any time?
Yes, Your Honor, 5 minutes.
Okay, Dawn, please. Thank you. All right, Mr. Niles, you may proceed.
Judge Bartley, Judge Allen, Judge Falvey, and may it please the Court, the Board of Veterans' Appeals committed at least 3 errors when in 2017 it surprised Mr. Smith with the finding that the same testimony that the Board had found to be credible in 2015 and again had found to be credible in 2016, now suddenly to be not credible in 2017 even though the relevant underlying facts had not changed. The Board's principal errors were as follows. Number 1, the Board violated Mr. Smith's fair process and due process rights by failing to provide him with notice and an opportunity to respond before it sua sponte reevaluated what Mr. Smith reasonably believed to be 2 prior favorable credibility findings. Number 2, the Board committed a Stegall violation because it failed to enforce the 2015 and 2016 remand orders that contained those favorable findings. And number 3, the Board erred under Barr v. Nicholson and related authorities because Mr. Smith never did receive the adequate for rating purposes VA examination and an addendum medical opinion that VA had undertaken to provide him pursuant to the 2015 and 2016 remand orders. And before I move on to fair process and due process, I'd like to make a final introductory remark, which is that the parties in this case are in one sense dancing on this ledge where Mr. Smith's, the issues that Mr. Smith briefed are narrow, but overlook broader and deeper issues such as are remand orders quote-unquote decisions, and can decisions of that nature contain binding factual findings and legacy appeals. Today, I'm going to be mostly sticking with the briefing and inviting this court to stick to those narrower issues that along the path that has been briefed. But if this court desires, Mr. Smith also prevails on those deeper legal issues for reasons that I would be happy to address. And so with that said,
could I ask one thing to get this on the table to make sure I understand your position as a general matter?
Yes, sir.
On the credibility, I'm going to call the credibility switch. We'll just, okay. You are not saying that the board was somehow precluded from making a negative credibility finding in the last decision. As I understand your position, it's that it couldn't do that without first, at least on your fair process, due process claim, it couldn't do that without first providing you notice that that issue was now in play. Do I have that right?
To answer your question directly, Your Honor, yes, that is how this case has been briefed. And this goes to the parties dancing on that ledge. So in Ray versus Wilkie, this court's fairly recent decision, this court made clear that even with an initial factual finding that goes to whether the veteran met some lower threshold just to advance to a next stage of analysis, if the board changes its mind from a favorable finding there to an unfavorable finding on the merits, it needs to explain why, and here the board did not do so. The hopping off that ledge for a moment, Ray versus Wilkie also poses this hypothetical claim where the factual finding, the initial factual finding is so definitive, and the changes, or the factual record is so static, there's nothing changed, that there might be no explanation the board could provide that would warrant changing his mind. And Mr. Smith certainly believes that this case fits within that hypothetical, but again, that has not been briefed, and Mr. Smith thinks it would be a perfectly acceptable result to stick just with lack of an explanation why. And so turning to fair process and due process, I describe this as one of those narrower issues up on the ledge because this court's law is clear. Whenever the board raises an issue sua sponte, it must provide the veteran with notice and with an opportunity to respond. And so in Marsh versus West, for example, the board sua sponte raised the issue of the notice of disagreement's timeliness, and for the board, that was a jurisdictional issue, which meant it was an issue that not only the board had the power to address, but it was one that the board had to address. And even there, this court held that to address that issue without giving the veteran prior notice and an opportunity to respond regarding the notice of disagreement's timeliness was error. And this court vacated the board's decision and remanded on that basis.
Now, what do you see as the difference between, so as a general matter, courts are going to apply the constitutional avoidance doctrine, meaning that if there's a non-constitutional way to resolve a case, they won't go the full distance to the U.S. Constitution. So the fair process doctrine is not one of constitutional law as opposed to the due process doctrine. How do you see them as being different?
Your Honor, I, on a functional level, do not have a strong answer. I do not know. What I will say that...
Well, that makes two of us. Okay.
What I will say on constitutional avoidance is that where I see that most often applied is when the court is breaking new constitutional ground. But here, this long line of cases, Thurber versus Brown, Marsh versus West, Bernard versus Brown, you can go to Austin and to Sutton. It's a long line of cases that all are on this issue and speak to that when the board raises an issue sua sponte, it must provide that notice. And so there's no new ground here. And so I would counsel that the constitutional avoidance doctrine need not be at the forefront of this court's mind in this particular case.
Well, let me just say, by the way, that this court in Prickett did discuss the difference between the fair process doctrine and due process. And I'm not saying it was perfectly clear to me, but you might want to refer to it.
Yes, Your Honor.
But on that note, your statement that we really don't need to be worried with the avoidance rule. My concern is that the board decisions that you're referring to that made what you call a credibility finding of fact don't really do that directly. In the 2015 board remand, the board did not make a finding of fact per se. I mean, I think that the secretary has some, there's some validity to his argument. That doesn't mean I'm perfectly convinced by it, but there's some validity to that because basically it was an instruction to an examiner to consider that the veteran was credible. And likewise in the 2016, whenever the the board refers to credibility, they say that the problem is the examiner was instructed to accept as credible the veteran's statement. So there again, they are not actually making a finding as to credibility, arguably, but just referencing an instruction that was given to the examiner. So that's kind of I'm not totally convinced. So convince me that this was actually a fact finding.
Your Honor, I will do my best to try. And I'll do this in two ways. The first is to accept the premise that there was no factual finding in either of the remand decisions. Certainly we do not agree with that, but my colleagues did make this argument, and it's a reasonable argument. Even if there are no factual findings here, the question is of fair process and due process. And so what does this look like to a reasonable person who is picking up the remand order from 2015 and the remand order from 2016? Mr. Smith waited for more than 4 years for a travel board hearing here, at which the judge who would be deciding his appeal had the opportunity to look him in the eye while he was testifying and see that he was telling the truth. And after receiving that travel board testimony and after reviewing all of the claims file, the judge issued not one but 2 remand orders with these instructions to please accept as credible Mr. Smith's quote-unquote credible lay statements, using credible at least as an adjective, as a characterization of lay statements, when the board could have written those instructions much differently. Could have just not used the word credible, and now I think I am bleeding into the why I think there's a factual finding. So I'll return to if there's not. There's still the question that this is about due process, and so how does a reasonable person interpret those remand orders? And it's Mr. Smith's position that any reasonable person would, under the facts of this case, interpret those orders as containing favorable credibility findings. And in fact, his services officer at the American Legion interpreted them just that way when preparing Mr. Smith's case on appeal when it returned to the board in 2017. And so now the second part of this, which I believe I started getting into a little bit, is that Mr. Smith does believe that both remand orders contain favorable credibility findings, again, because of the use of that adjective, credible, before directly modifying the words lay statements. If the board had not intended to make definitive findings of fact there's other language that the board could have used, such as assume assume these facts, and you don't see this often in board decisions, but could have added a sentence, the credibility as to which I am reserving judgment. The board was limited only in its creativity in how it set up the instructions to the examiner, and it chose the words that it did. Please accept as true the veteran's credible lay statements. Now,
and if there had been some qualifier in there, that is, the board remands said, we haven't decided this yet, but examiner, you consider these statements credible. That would have, you wouldn't be here.
That's correct,
your
Your Honor.
position?
That's correct. But the board did draft those remand orders the way that it did, and as far as I believe Your Honor referenced, well, these are just instructions going to the examiner as opposed to the narrative of the remand orders. In 2015, that's absolutely correct. In 2016, I find the at least very similar language, both in the narrative and in the instructions. I would also say that if what the board is saying, if it looks like a duck, if it quacks like a duck, it doesn't have to be in a big pond that says duck, that a favorable factual finding can be anywhere within this remand order. Returning to Marsh versus West, this court also addressed prejudicial error. And it articulated the standard that the veteran has to show that the error is not harmless, and that standard is very permissive to the veteran. And so in Marsh, Mr. Marsh had proffered no theory under which his notice of disagreement could have been deemed to be timely. But even there, this court held, and I'll quote from the decision here, we are not prepared to rule out the possibility that the appellant might have been, and indeed on remand might be, able to convince the RO or BVA that his NOD was timely. And so Mr. Smith submits that when one compares the facts of Marsh side by side with the circumstances of his case, where again he had waited the 4 years for the travel board hearing and all the facts that I mentioned, that his circumstances go well above and beyond what this court requires for showing that the error was not harmless. And so for all of these reasons, I'm sorry, I saw your eyes and thought you might be asking a question. For all these reasons, on fair process and due process, Mr. Smith does ask that this court vacate the board's decision and remand on that basis.
Could I ask? No, go ahead.
Well, okay, so explain to me what process you want here. So the board made these two remand decisions, and they got this final VA opinion, and it's back up at the board, and the board realizes, yikes, we actually indicated that the veteran was credible, and they start looking deeper into credibility. I'm just assuming what happened, and that this is what happened in this case. I have no idea exactly what the thought process was, but they're like, damn, we made a mistake. What should they do? Tell us what you want the process to be.
Your Honor, to answer this question, if I may assume that Mr. Smith loses on every single other issue, so that the only thing we're talking about is fair process and due process. In that case, just as is required under this Thurber line of cases, including Marsh, just notice, hey, I'm worried about this credibility determination. I want you to make a showing and provide some reasonable amount of time to proffer rehabilitative evidence, which I will proffer that if Mr. Smith had known in 2017 that his credibility was suddenly at issue or open again, he could have and he would have made a proffer or would have submitted rehabilitative testimony in the form, and this is not in the records, but this just to the extent that it helps this court's decision-making process, he was prepared to, or he would have, if he had known this was an issue, provided additional testimony from himself, and he believes that he would have been able to submit buddy statements as well.
Could I, so,
Okay, as long as you can take Judge Allen's questions, as long as you continue with the process that I asked you, so.
oh, I thought you were done with, I thought your answer to Judge Bartley was, tell me that it's an issue, and then I would have submitted more evidence. I had assumed your answer was done. If it's not, I didn't want to ask you another question yet.
My answer was done, but this may be just the lack of my own creativity. If there are additional safeguards that would be appropriate there, certainly Mr. Smith would have appreciated being able to avail himself of them. But at a minimum, he should have been informed that this was an issue and had just the opportunity to make a submission.
A written letter to the veteran identifying that earlier remands might have led the veteran to misconstrue that he was in fact credible, and that they intend to write a decision that would find him not credible, and then give him how much time to respond? Do you have any sense? I mean,
yes, Your Honor, and when I think of time periods before the board, I default to 90 days, but that is something that I am coming up with right here, right now. Another time period might be perfectly appropriate.
And that 90 days is the 1304?
Yes,
Greg,
Your Honor.
is that why you're getting that?
Yes.
Okay.
Yeah, well, my question was just, you have two other errors here,
Yes,
right?
sir.
And given the answer to Judge Bartley about what the procedure would have been, right, which it seemed to me was the way in which it would come out, right, which is, I think there's a problem, okay, submit some evidence in some period of time. Assume that we decided here just that the medical exams were not adequate, or that they didn't comply with Stegall. At that point, we wouldn't even have to address, unless I guess we wanted to, the fair process or due process issues, right? Because the remand to the agency on the, say, the substantial compliance point would actually solve your notice point, right? Because you're on notice now that the board doesn't think your client is credible, which means there's no issue anymore because you're going back and you get the right to submit evidence and all of those types of things. So am I missing something, or is that one way that this could be done?
I hope that it is one way that it could be done. And I will say, too, that there's tension in the law between cases such as Best, that counsel for narrow decisions from this court, and cases like Corinne that say, well, this court certainly has the authority to provide additional instructions to the board on remand. I personally find myself leaning over and over again towards Best. I'm actually arguing that before this court in another case. In this particular circumstance, though, where for at least the last several years, the board and the regional office proceedings have been a bit messy, and there are several different sort of even ledge level or narrow issues that are at play here. This is a circumstance where I would ask that, especially with this claim that having been pending for 11 years now, that this court go ahead, and these issues are all narrow, so please do provide guidance for the board on all of the errors that it has committed, including this fair process, due process, just to make sure that credibility, that he gets his fair shot there, which he absolutely should. And Stegall. And the Stegall violation is quite straightforward. The 2017 board decision acts essentially as if Stegall did not exist. It makes very quick passing reference in the introduction to the decision that, yes, there was a 2015 and a 2016 remand orders, but then it does not address actual compliance. It does not address substantial compliance. It does not even so far as mention Stegall. And so we know from cases such as Matthews versus McDonald that is error and requires vacator and remand for correction. We also know the error is not harmless, and this I think slides more into the bar type arguments because, as Your Honor mentioned, there, or at least reminded me that there are these inadequacies in the VA examination and the addendum medical opinion. So, number one, the examiner was instructed to accept, whether it's a finding or not, was instructed to accept as credible Mr. Smith's lay testimony that there had been this hatch occurrence aboard the USS Sumter in 1990 or 1991 that had injured his left shoulder, that he was in a brace or a sling for several weeks, and that he had suffered intermittent pain ever since. So ever since 1990 or 1991, and even when you combine the VA examination and addendum medical opinion, they only ever go back to 2002 in terms of what they look at. And so there's this 11, 12-year gap in what the examiner had been instructed to accept as true of at least intermittent left shoulder pain throughout the entirety of that time.
And in your view, intermittent suffices for continuity? Are they the same thing in your view?
I'd like to take three different answers to that, all quick. Number one, it is an examiner rather than this court or the board saying intermittent versus continuous. And so I think it needs to be taken in that context where it's not an adjudicator but rather a medical examiner who is using that term. Number two, there is focus on continuity of symptoms in the briefing, and certainly if Mr. Smith had continuous left shoulder pain, that would be relevant to nexus. But even intermittent, we know under 38 CFR section 3303D, he has at least tendinitis. Tendinitis is not one of the listed chronic conditions for presumptive. It's one of the listed presumptives. And so there could have been manifestation anytime. It didn't have to be continuous. Intermittent would have been fine and relevant to this nexus opinion that the board was instructing the examiner to provide. Another shortcoming of the examination and addendum medical opinion is that, so in the 2016 addendum medical opinion, there's this rationale section that lists out 4 points. And the second point suggests that the medical examiner was, that the opinion was predicated on objective, quote unquote, objective evidence. And that seems to fly in the face of this instruction that, hey, you have these credible lay statements, accept them as true, and to fly in the faces of cases like Buchanan that renders this examination inadequate for that reason as well. And I will mention that to the extent that the board did make favorable findings in its remand orders, and that the examiner is actually disregarding them and making these opinions under some different understanding of the facts, that has to be seen as an inaccurate factual premise, which further renders the examination inadequate. And so for all of these reasons, and I realize I've meshed in some ways the Stegall and the Barr-type points of errors, but there are additional reasons why Mr. Smith requests that this Court vacate the Board's decision and remand for correction. He also stands on the additional issues that are in his brief that I did not address today, which provide yet further reasons for vacater and remand.
Can I ask one last question before you sit down? Is there any problem with the instruction independent of this point about whether it was a finding of credibility or whatever? Because, so the veteran in this case had many statements, right? The statements about what happened, the statements about the pain that happened then, the statements about pain that happened later. And I'm not exactly sure what I would do if I got this and was an examiner, because it says that you accept as true the veteran's credible lay statements, and then it says regarding the lower hatch. But do you read that to say that the Board was telling the examiner to accept everything as credible?
No, Your Honor, I do not. I do not.
How do you read it then?
I read it, so I would hesitate to require the Board to list out every single fact that is individually found to be credible in every single instruction for a new examination or medical opinion. And I would limit I would understand as the Board judge specifically limiting, so you have this regulation 38 CFR 19.9 that describes sort of when remands are necessary, and there's also guidance, I believe, out there on how the Board judges should frame it. And I believe there we have to trust the Board judge more or less that they framed this instruction exactly as she intended.
So basically the two things that follow that, the injured left shoulder while lowering hatch resulting in several weeks in a brace and having intermediate shoulder pain ever since.
Yes, Your Honor.
So it couldn't be read to say, you examiner accept as true the credible statements, but disregard the incredible statements, and I'm charging you to make credibility determinations.
That's right, Your Honor. Where if I understand, and I'll try to rephrase just to make sure I am understanding your question, where the Board judge said, please accept as true the veteran's quote-unquote credible lay statements, and then it goes on. I would have a problem if the instruction went on to then list a series of facts that the Board judge had found to be incredible. This is not a symmetric system by any means, but by listing 3 facts that the Board judge found credible instead of 7 facts, that is something where I do think we have to trust the Board judge in this particular case. Thank you, Your Honor.
Thank you, Mr. Niles. Mr. Walensky, you may proceed.
Good morning, Your Honors, and may it please the Court. The Board's credibility determination was supported by an adequate statement of reasons and bases because it was premised on several factors and was well-reasoned. Contrary to appellant's argument, the Board did not reverse a credibility finding because the prior remands did not assess appellant's credibility. The Secretary requests that the Court look at the context in which appellant premises his argument on and the statements made in the Board remands, and notes that they were directed specifically to a medical examiner, were found in the Board remand, the directives of the Board remand, and were conditional statements.
But how would, so I have seen other cases in which the Board member remands to an examiner and does what I actually think is an excellent practice. Because it cuts off sort of the point that Judge Falvey was raising right at the end, which is assigning to the examiner an implicit, you make a call about what's true or not, which of course is not what the examiner is supposed to do. So I have seen remands that say, assume that the veteran's statements on these points are credible. And in that case, I think no reasonable person could read that remand to say that the board itself has already made a credibility determination. And in fact, the board is doing, in my view, an excellent job because it's cutting off a potential error that we could see from the examiner. But here, let's assume that's what the board meant to do, the board member. How would anybody read this to know that that's what it was, since it twice used the term not assume it's credible, but take as true the veteran's credible lay statements about two things? So whether or not the board actually made a finding, right, isn't the fundamental point appellant makes on his first argument is that lulled me into a sense of security on these points, and you just had to tell me that, in fact, wait, I didn't really make that finding yet. I mean, that's the fundamental point, right? How would somebody tell that from this?
So if you can bear with me, there's a number of reasons or a number of factors in play. Initially, by not granting service connection, that inherently states or shows to the appellant that your statements are not credible enough to grant service connection. And so in asking for more development, it is saying that what we have of record previously is not, at this point, sufficient to grant. But also, specifically in that remand, at record at 873, it hedges, or it states the purpose for the examination opinion and says, for examination purposes, assume the credibility. And so we have there a direct statement to appellant that this is being sought for examination purposes. And then also, underneath the Veterans Law Judge signature, there is a direct citation to 20.1100 and states that this is not a decision on the merits of the appeal. And so, coupled together, there has been only an assumption of appellant's credibility for purposes of providing an examination, but there has been a deference or deferral of the actual assessment of that credibility until the merits.
Okay, here's the problem I have with that. We have a case that I know you're aware of called Riamal, which says that if an examiner bases an opinion on an inaccurate factual premise, then that opinion is worthless, essentially, or will have reduced weight, but probably worthless. You know that case.
Yes, Your Honor, I'm
right?
aware of the premise.
Right. So why would the board have ordered an examiner to assume credibility when they hadn't determined credibility at that time? Because any opinion that was issued would be essentially worthless if that assumption turned out to be inaccurate, and the board didn't know ahead of time, in this case, that it would eventually determine that the veteran was not credible. So why would they get an opinion that essentially had at least a 50-50 chance of being completely worthless?
Well, respectfully, Your Honor, in obtaining an opinion, it was, at the time of November 2015, it was in furtherance of appellant's claim for benefits. The medical opinion that was requested was specifically in furtherance of the key theory of entitlement that appellant had supported or had theorized. And in that exam question, it is assumed for the purposes of this examination that the complaints of intermittent pain are credible. And so VA was attempting to obtain a medical basis or medical understanding that could support appellant's key contention that he had continuity of symptomatology.
Without having assessed the key contention.
At the time,
like if they had done a credibility determination right off, they wouldn't have really needed to develop as to linkage, would they? Because, I mean...
Without deciding the case from the podium, yes, Your Honor. I mean, there is a scenario where instead of the remand, there could have been a denial of benefits. And then the litigation would be over the McClendon analysis, essentially, as to whether or not exam would be warranted. And so at that moment in time, VA provides the exam in hopes or in development in the possibility, the potential for more evidence to come in to substantiate appellant's claim, as opposed to potentially of denying the claim on its face based upon credibility determination in November of 2015.
Leading to the issue we have here. But your explanation makes me think that if they went ahead and asked and assumed credibility just to get evidence, knowing that any evidence based on that assumption could fail completely, it makes me think that maybe they actually did assess the credibility in the first instance early on, and now are actually reversing their position.
Respectfully, Your Honor, the prior remands did not provide an assessment of credibility and only assumed that an examination was warranted based upon the facial plausibility of the statements provided by appellant at that point. An analogy, it really is akin to numerical evidence standard in that the evidence that we have is sufficient to provide an examination. VA provided the examination with furtherance or in the attempt to substantiate the claim. It was not done in a negative manner or in search of negative evidence, was provided another opportunity for appellant to submit more evidence, and was searching for a medical underpinning to appellant's theory. Before even weighing or assessing the board remand directives, it is also important to note, as the Secretary argued, that board remands are preliminary orders and are not final decisions and are not binding on the board in any way when it reassesses or it provides its merits analysis. What is important to note, though, is that so in terms of what development was owed to appellant, there is no, VA cannot change or cannot no longer provide that development. I mean, that is squarely within the Matthews case from this court in that VA must provide the development or explain why the development was not given. And so,
I don't understand what I agree with the legal principle, but I don't understand why that matters at all to this question.
In the instant appeal or to?
Yes, I mean, so I may be just, there's a judge on the Ninth Circuit who likes to say I'm just a little country judge from Idaho, but I may be saying this entirely wrong. It has nothing to do for me about whether a board, these decisions are interlocutory. Frankly, it doesn't even matter to me whether this is a credibility finding or not. It's that the language the board used not once but twice, most naturally read to a veteran would be, they believe me. And they clearly think they need something else because they didn't grant me a benefit, but they're asking for a medical exam. This is all good, but they believe me. And then I am told, I don't believe you. And it's just a question of the way in which the board phrased it. A natural person would think they had made the determination, even if they hadn't. And I see this as a very low ball. All the appellant seems to be asking, and I asked him specifically at the beginning, Mr. Niles at the beginning, is just tell me that this is in play. I'm not saying you can't do it. I'm not saying you're bound by anything. Just tell me that, hey, I might have misled you a little bit, or hey, I see how you would have done this. If you want to have time to rehabilitate yourself, go ahead. That is such an amazingly low thing to ask the Secretary to do, in my view, in a pro-claimant system. It's just surprising to me that we're riding this horse of what I'm going to call bad facts for the Secretary that could lead to bad law being made for the Secretary on something that probably was just an inarticulate way the board did it. So I want to get your reaction to that, right?
Well, that's a loaded question, or there's a lot there to unpack. But
it's probably both.
Yeah. Directly going to a due process concern, I mean, it's something you had mentioned previously, Your Honor, that typically the due process concern is second or third in the analysis as opposed to the primary analysis. And so what we have here is essentially an assertion from appellant. It's solely in the context of a reasons and bases error. And so that's also something that the Secretary would like to point out, that if there is a reasons and bases error or perhaps a Stegall error, that itself warrants remand and would not preclude, but would dictate against coming or assessing the due process violation on its merits. Because if the board decision, for instance, has lacked adequate reasons and bases, well, then a decision properly explaining the basis of its decision would be warranted. So that's the Secretary's first position with regard to the due process concern. There's also another concern with the due process in that appellant must show reliance, and that I don't believe has been fulfilled by appellant in this circumstance, and has merely stated that they have been misled. Now, to the extent that it is reasonable or a reasonable person would have been misled, that's why we are here and that's what we are discussing. But the reliance portion, as this case, or as this court stated in NOAA, is also part of that analysis. And the Secretary made an argument in briefing regarding prejudicial error that absent any positive evidence, this court should take due account of prejudicial error and find that there has been no prejudicial error.
On that point, Judge Bartley wrote a decision recently in Simmons that talks about prejudicial error. Basically, one of the notions of that is, at the core of it is has the error essentially one aspect of it is has it sort of affected the adjudicative process, right? Because if there's some error that sort of alters the way in which a party, say, submits evidence, right? We can't really have confidence in the process because something isn't there that might have been there, right? Mm-hmm. And so here, isn't this sort of the quintessential aspect of a situation like that? And what I mean is, just assume that the board's decision takes off the table, the earlier remands took off the table a factor. Here, credibility, right, about whether the incident happened, let's say, okay? One might say, if lulled into believing that my statement that it happened is good enough, I'm not going to spend the adjudicative time to support that allegation because it's already, I can check the box, right? So isn't that fundamentally it, is that the allegation is that, hey, if I knew this, I would have done more to provide a more fulsome statement or gotten a buddy statement or something like that. I mean, it just seems it alters the mix of evidence.
There are two responses to that question. And first, the global response is the benefit of service connection was always in dispute. Service connection had not been granted, and that had been reminded to the veteran via remand, a statement of the case, and SSOCs. But also to the specific part of the question talking about disbelief in what had happened, here the board did not pull the rug out from the veteran and say we no longer disbelieve or do not believe that the second element or the in-service occurrence hadn't occurred. They conceded that the Hatch incident has happened, and what we have is actually a assessment of the credibility specifically with regard to lay statements regarding continuity of symptomatology.
Right, I was using the Hatch as an example, but my point being that if an error is generically one that would lead a reasonable litigant to no longer present evidence on a point, then I think the harmless error process becomes much harder to assess because it's not saying, well, but there's nothing there because the error itself lulled somebody into not putting something there, right? So, for example, on the continuity of symptomatology, right, you could have had lay statements from others besides him, right, which the board then could have weighed and still found it all incredible. But that's my point on the harmless error thing. I think in a lot of cases harmless error can carry the day because we're required to look at it. But here, I wanted to get your reaction to the fact that it changes the balance of evidence.
Mm-hmm. Yeah, and here the veteran had the opportunity to provide evidence in support of his claim after the remand, after the SSOC. But again, the Secretary would like to highlight the record at 873 to 875 that there is a notation at the top of the page that the credibility is assumed for medical purposes, that the credibility is estimation that Judge Bartley used to begin the proceedings was in a notation directly to an examiner, and again, below the veteran's law signature was a notation that this was not a decision on the merits. And so a reasonable litigant would not or should not understand what has happened in that remand to fulfill or to have been an assessment of his credibility or to have been favorable on any merits of the adjudication up to that point.
Just on your earlier point that appellant hadn't submitted evidence of reliance, in NOAA, didn't this court remand for the assessment of whether the veteran had relied on a notification that was found to violate due process?
Ultimately, yes, Your Honor, but there the due process violation there was a improper notice or communication by VA. It was wrong. The legal notice provided was wrong on its face, and that and Cushman with regard to the altering of material evidence is so distinct or so dissimilar from what we have here, which is essentially we have a de novo review that is now being deemed a due process error, and again that also assumes that the board had even made a prior credibility determination that it could have reversed. And again, the Secretary's position is that there was no credibility finding in the prior remands.
Yeah, but if we found that there was a finding and that it violated some kind of process that was due the veteran, then couldn't we kick the detrimental reliance issue back to the board?
At that,
as the court did in NOAA, is my point.
yes, and also if I may, if that's also assuming that there has been a determination by the panel that there's a reasons and bases error, because at that case then it would be.
I would call it reasons or bases, but I get your drift.
All right. So yes, but to also though the board remand, and specifically in this case, did not contain factual findings that would have been required to have been, or that the board would have been bound by in its November 2017 decision. The Secretary cited in his brief 20.1100, which notes that board remands are preliminary orders, and there was nothing in the remand narrative of either remand that would suggest that the board had found appellant credible in any regard, except for the fact that facially the statements that were provided could have substantiated a claim for service connection, and therefore remanded for development on that basis. A final point that the Secretary would like to make is that 38 U.S.C. 7104 instructs that the court take review of a final action or a review, that the board provide one review of the evidence. And that speaks to the power of de novo review. And while we do not have a circumstance where there's been a reversal of credibility findings, what we have again here is a deferral of the assessment of the veteran's credibility, and then was assessed in that de novo review in November of 2017. And it's the board's ability to fact find and weigh evidence in the first instance or in its final decision that is paramount here, and part of the Secretary's analysis that the weighing of the evidence and the credibility determination was proper and was properly undertaken because of the nature of the prior remands having no binding effect on the eventual adjudication. If there are no further questions, Your Honors.
Thank you, Mr. Walensky.
Thank you.
Mr. Niles, you may proceed.
Three quick points, Your Honor. The first is to clarify something that I said earlier when I was speaking of trusting the board judge. I just wanted to be very clear that I was not meaning to imply any sort of limitation on the review that this court should take, but rather just that words matter. And when this court looks at what the board judge did, it should look at the words in those remand orders. My colleague has asked this court to focus on a small subset of words in one of the two remand orders that are at record 873. I would ask that this court look at all the words in both of those remand orders to include the very page before, the record at 872, which is in this 2016 remand order, where the board didn't just give these instructions to the examiner. It also here put down a narrative, and in that narrative, the board judge took the examiner to task for not, perhaps, for not being clear that they had followed the 2015 remand order. And in part of that, the board says, moreover, in providing a negative opinion, the examiner specifically relied on a September 2008 VA treatment note documenting a report of a 1-year history of shoulder pain precipitated by working at a car wash. However, the board observes earlier complaints related to the left shoulder, including during March 2002 treatment. Now, the board had no reason to make that observation unless it was making a finding of fact. That's all I have to say on that. Number two, the third point that I wanted to mention was one of the first things I said today was that the parties are dancing on this ledge, and I feel the Secretary continually trying to jump down. And what I understand the Secretary's position ultimately to be here is that there is some per se rule against remand orders ever containing a factual finding that is binding. I understand that argument to be premised on this understanding of 38 CFR 20-1100B, the second sentence in there, to somehow transform all remand orders into all remands into preliminary orders. And so there's this speaking of well, are remands final decisions? Well, no, they're not. We know that. But are remands decisions? If this court gets into that, if it jumps off that ledge, then yes. Remands are absolutely decisions, irrespective of whether they are final. And that triggers a whole host of other regulations that go well beyond the briefing, but that Mr. Smith would be happy to address.
But you're only making that point in response to his argument that they're not bound. You didn't really make the argument that they're bound by the finding.
That is absolutely correct, Your Honor. If Your Honors have no further questions, then that is all that Mr. Smith has.
No, thank you. Thank you both very much for your arguments. The case is submitted for consideration, and the court will come down and greet counsel.